Hey everybody, I'm watching everyone kind of trickle in that was in the waiting room. We always start a couple minutes early and just let you guys kind of filter in and more people come in. We're probably going to get rolling around actually 10:05. So we'll give it another 5 to 7 minutes and just kind of hang out here together. In the meantime, if you guys have any questions, you can always use the chat feature to ask me and Lindsay whatever is on your mind. If we don't get to it at the front, we'll get to it at the back end of the talk. If you don't know us, I'm Geoffrey Middleton. I'm one of the attorneys with Munger and Middleton. And this is Lindsay. She's your agent liaison. I guess this way. And you guys have already been in contact with her through this process. And we always appreciate Lindsay and her help getting these together. Looks like everyone from the waiting room's in at this point. Lindsay, you got any?
Put up our poll.
Yeah, our poll. I forgot about that. While we're waiting to get started, guys, we've made the poll active. You can go to the right side and you have the chat, the poll, and the handouts. The poll should be popped up at this point. You can go ahead and click which one you are most like. We always like to figure out who's in our class and where we need to tailor where we're going with our PowerPoints and our presentations and see what brought you here. Lots of realtors on a rental property.
Yeah, I feel like I've been talking to more and more lately who do both. All right, you want me to do my quick rundown?
Yeah, sure. Let's go ahead and jump in.
Okay, so as Geoffrey said, I'm Lindsay. I'm the realtor liaison for Munger and Middleton. I think we have a couple people in here who are not regulars in our classes. So for those who don't know, my job is just to communicate with you throughout the time that we have a contract with you, let you know what's going on, what's outstanding, and make sure we close on time. Aside from that, I have also registered all of you guys for our email list. So that's where you will get invites to all of our future classes. We do one of these classes the first Tuesday of every month. And then on top of that, we also send out a monthly newsletter with a whole bunch of info about Huntsville. And that is specifically for you guys to share with your clients. So we kind of do all that work with the gathering of information so that you can send it out and help your clients, find new cool stuff to do in the area. Especially because we have so many people coming in from out of state lately who may not know the area. We do have our August class, which has been announced, and that is going to be another one on cybersecurity for realtors. And Geoffrey will talk a little bit more about that at the end of this class, and we'll put up a link for you guys to register. But stay tuned at the end because that's very, very important, and we do want you to hear about that. For this class, as you can see, there's a chat feature on the side. If you're on your computer or on your phone, it might look a little different. On your phone, I believe you can swipe, and you should be able to see the chat. Along with the poll and any handouts that we do. If you are on your phone, we are going to be putting up links throughout the class to different websites. And on your computer, you should be okay. It'll just open another tab. But if you're on your phone, it will take you out of this class and you won't be able to hear or see us. So if you're on a phone, maybe wait until the end to click those links. They will stay up if you don't click them immediately, so you can do it later. And if any of you have any ideas for future classes, then let me know. You should all have my email address at this point, but I'll type it in the chat just in case. We do have one for every first Tuesday of the month for the rest of the year, but we're flexible. So if we get a lot of interest in an idea that we don't have up yet, we are happy to add it to our list.
That's right. And if you see any handouts that you forget to click or you don't know where they get and we don't email it to you after class, just get in touch with me or Lindsay and we'll make sure you get the handouts. We always keep those going.
Also, if you get kicked out of this at any point, you should be able to just come back in without issue. And in case you miss anything, the session will be recorded and you will receive an email with the link to it after the class.
That's right. To my horror and hopefully your help. All right, so like we were saying, just a couple more minutes. We're going to give people to the stragglers, kind of give them a chance to come on in. And then, like I said, about 10:05, we're going to go ahead and jump into the presentation. If you guys have any questions at any point, go ahead and type them into the chat. And then we'll go through the chat at the end of the class and look for those questions and make sure everyone's questions gets answered before we get over. We usually try and talk for about 20 minutes, 25 minutes, and then we try and leave the rest of the class open for questions, whether they're related to the topic at hand or really any questions you guys might have. You guys have me for an hour, so I'm going to try and fill up as much of that time with me talking as I can, but your questions help.
I guess I will duck out so you can get ready whenever you are.
Sounds good. Hi, everybody, my computer shows 10:05, so we're going to go ahead and dive in. If you haven't been to one of my classes before, I have pictures of my dog all over my slides just because it's fun and he likes to pose. And so you'll see him throughout our slides today. Our topic at hand today is evictions and the basics. So we're going to talk about all the COVID moratoriums that have been going on and kind of their timelines and where we're at with those and how they're affecting our process. And then we're going to talk about the basic outline of an eviction, how we go through that timeline, and things that you guys need to be aware of as the managers for those properties. Also, I hope everyone had a good 4th of July. I had a great weekend. We did a lot of family events. So I hope everyone else did too. So what is an eviction? This is, I know, a very basic question, but this does confuse some people. An eviction is called an unlawful detainer from the legal side of things. It is specifically when you have a landlord-tenant relationship, and we are going to use that lease that defines that landlord-tenant relationship to remove the rights of an individual and take their possession back and go after them for damages or for back pay on rent. All that happens in the district court. Now, sometimes you get situations like in a foreclosure where it's not a landlord-tenant relationship that's been terminated, it's a different type of relationship. Or maybe you even have a squatter where no relationship ever existed. You can't evict those people because they're not landlord-tenant relationships. Those are generally going to be ejectments where you have to go in and remove someone and their possession of that property that they're holding illegally. That's going to be in circuit court. It's the same kind of thing. You can go after them for taking possession of the property and getting damages for that property as well. The key reason we have legal processes for these things is because we don't want to incentivize landlords into being violent with their tenants or with people who are on their property. And so the courts want to come in and say, let's establish who has the rights first. And then after that, we'll have the sheriff or somebody come in and help you actually take possession back so you don't get into any further entanglements with legal battles with these people that you don't need to be involved in. Jumping right into our moratoriums and where we were at and where we've been. Everyone knows we started with our pandemic back in January of 2020. Feels like a lifetime ago. But the CARES Act went into place on March 27th, and you had the eviction moratorium. It actually didn't go all the way to August 23rd. It went just before that. But August 23rd is when landlords were allowed to actually start eviction processes. And so the CDC came in around the end of that period, and they said, hey, we've been watching this, and due to the high infectious rates and the high likelihood that if people get evicted, they're going to have to go somewhere, and that somewhere will probably be a place with more people because they're going to have to get into tighter quarters with more people. But that's not a good idea for an infectious disease. And so we want to, since Congress won't do anything about it, we're going to come in and say this is a public safety issue, public health issue, and we're going to ban any evictions based on failure to pay rent. They started this on September the 4th, so you really only had a week between August and September the 4th where the two moratoriums weren't in place, and that went all the way through December 31st. It has since been extended, as you can see, multiple times. to get us all the way through our current extension, which is through July 31st. Now, the CDC moratorium, if you don't know, this is the basic overlay of what it does. It is a temporary order, like we said, that will expire. It is based purely on paying rent, and based on that lease agreement. It is not meant to prevent you from evicting people for doing illegal activities, or for destroying the property, or for other eviction warranted activities. This is strictly that what we're talking about here is failure to pay rent. To qualify under the protection, you don't automatically qualify. The tenant has to present their declaration saying that they have met the elements that are required to be a covered person, and they have to present that directly to the landlord or the owner, and they generally have to bring it with them to court as well, and present it to the court as having previously been presented to the owner. Tenants are liable for perjury and additional criminal penalties if they lie on those statements. So a lot of people have said, that's really unfair that they can just sign a piece of paper with no, penalties against them for lying. Well, I mean, if they lie, you can go after them for perjury and for criminal penalties. And in addition to that, as a landlord trying to evict someone, you can challenge their statements. So if they sign something and you don't think what they're saying is true, you can tell the court, I don't believe them. We have this evidence over here saying that that's not correct, and it's up to the court to decide how they want to handle that situation. We're going to jump right through this, get into the fun stuff. So you can be proud. The Alabama Association of Realtors met to the Supreme Court on your behalf. They challenged this moratorium earlier this year, and they said this has gone too far. The CDC is dragging this on too long. The CDC didn't say that we couldn't ever go after them for rent, but they're taking too long. If someone hasn't been paying rent since, gosh, what was it, last March? Yeah, last March. I mean, you're looking at over a year's worth of rent by the time they got to the U.S. District Court that the CDC is continuing to pile on to this cliff edge. And they said CDC's gone beyond their statutory threshold for power, and they should be told they can't do it anymore. And the District Court actually agreed with them. And they said, yeah, we agree, but we're going to put a stay on our order because we want this to be appealed. We want the government to have a chance to deal with this, and we don't want to interrupt the government process. And so the government did appeal it. They went to the Circuit Court of Appeals, or the U.S. Court of Appeals in the District of Columbia, and they decided to just rule on the stay. And they said, yeah, we're going to leave it as a stayed order, and so we're not going to enforce the order. So then the Supreme Court got involved, and they said, you know what, Supreme Court, we want you to overturn the stay so that we can actually enforce this District Court ruling saying the CDC doesn't have the power to do what they're doing. And the Supreme Court said, well, we technically agree with you guys. We also think the CDC has gone beyond their statutory authority. But considering what they're doing and how we have combined their role with getting rent help out there, rent assistance, and other funds that are being applied through this program, they said it's already set to expire on July 31st. So what we're going to do is we're going to leave the stay in place. We're not going to enforce the ruling overturning the CDC moratorium, but we are going to tell the CDC they can't go any further. If they go any further, it's going to require congressional authorization saying they can do this specifically, or Congress actually doing it themselves. So we can all rest assured that this will only be an issue for another 25 days. So now that we've gotten through kind of the pandemic, where we've been with the eviction process, kind of the new things that are happening, I want to go through just the basic unlawful detainer process. So like we said, the unlawful detainer is what you have when you're actually doing an eviction. Just real basically right there, you see my quick walkthrough. We need to start with your lease provisions. So if you are a manager of property, don't take your leases for granted. Review those provisions, especially the default provisions. A few years ago, the legislature came through and said, we're going to revise the requirements for what's the minimum amount of time period that you need to evict somebody. It used to be 14 days was usually the standard that they went to, and it's now 7 days for everything. And so failure to pay rent needs to be updated in your leases to say 7 days for failure to pay if it still says 14. because we are always going to fall back on that lease to see what you guys agreed to. The notice of termination process is actually what we're going to talk about with this flow chart. So give me 1 second to switch gears. All right, so this mess of a chart kind of shows you what we're going to do as we move towards the eviction, and then once we're in it, how it works. So starting at the very top there, you can see we entered into that lease that we just talked about that has the correct provisions for default. Tenant fails to pay rent. Well, what happens next? You have to give notice of termination. That is the first step in every eviction process. You have to give your notice of termination. This is not a notice of failure to pay rent. This is a notice that says you failed to pay rent. You've had your time that the lease says you have to be able to pay it. We are terminating your lease. And if you want to reinstate your lease, you need to pay me this much money by this time period, usually 7 days. And if you can pay me all the money within 7 days, great. So then we go on to the next thing. We say, did you accept money during that 7-day period? Well, if you did, we're going to the left. Great, they paid everything. Now we can reinstate the lease in full. Everyone's happy. You really only have to allow them to do this 2 times per year. After the second time, you no longer have to allow them to pay rent. You can just give them a notice of termination and say, sorry, you can't renew your lease. Like, you can't reinstate it. Let's say they want to pay partial, but they don't want to pay the whole thing. Well, by accepting any money from your tenant during that 7-day period, you have agreed to reinstate the lease by default. That is the agreement there. I'm accepting money, and if I'm accepting money, that means I'm operating under the lease terms. So we obviously must have reinstated the lease. So that means we have to give a new notice of termination when they make their next failure to pay. So once they fail to pay, we'll give notice of termination again, and then we're back down to the 7-day period. All right, we get through the 7-day period. No one's paid any money. Now we file our unlawful detainer, and we get to serve our tenant with their papers. Now this is a big part for me, because if we are strictly trying to get possession back, which in my opinion is the most important part of this process, I want to make sure that you as a manager are working for your actual owners to get possession back as soon as possible. Because once you get possession, it's a whole line of things that need to happen next, as far as fixing the property, making sure you can turn it over to the next tenant. We're trying to mitigate your damages for your owner. And so if we try and go after them for money and back paid rent during that time period, we have to give them personal service. And that is a perfectly fine thing to do. A lot of people want that personal service, and let's go after the money right now. But you do need to know that that can delay how quickly we can get back into the property, because if you have a tenant who is a professional dodger of these things, it can be difficult to get them served. Whereas with a possession-only eviction, all you gotta do is post it on the door. And so we can typically get them served within 24 hours. So I always prefer to go after possession first. Now, by going after possession only, we are not saying we're never gonna go after the money. We're just saying our first priority is possession. And then once we have possession, we can total our damages, total our rent payments, and then we can go back to the court and we can say, usually in small claims, they owe us this amount, here's the lease, they didn't pay it, it's a straight cut forward kind of thing. And so we can work that out on the back end. So the next process after we get the unlawful detainer filed and the tenant served is they have a 7-day period in which to file an answer. If they do answer, no matter what they answer, we are going to court. Even if it's just to say, hey, my name is so-and-so, I disagree. Now we're going to court. Then you have to tell why. The court's going to have to schedule us for docket. We're going to talk about it. If they don't answer, then that's the best case scenario for a manager, because we're just going to file for a default, saying they didn't show up, they didn't answer, we filed everything properly. And so at this point, we're going to submit all of our documents to the court. We're going to submit the lease, the original notice of termination showing that we properly gave them notice. And we're also going to give them notice that we properly served the tenant with the papers. And then once we have all those things together, we're going to ask the court to look at all that and say, all right, you did everything correctly. It's the tenant's fault for not showing up. Here's your default judgment. Once you have a default judgment, the tenant has 7 days to leave the property. After that 7 days, you have to do what's called a writ of possession. A writ of possession is where we essentially go to the sheriff and we say, look, we've been given, excuse me, we've been given possession of the property given back by the court, but the tenant's still there and they refuse to leave. So we need the sheriff to come out and stand with us while we remove their possessions from the property. You have to note on this part, if you haven't been through this before, the sheriff will not do anything. They will show up and they will monitor the process to make sure nothing happens, but they will not engage. It is your job to have people on standby on that day that the sheriff agrees to come out to remove their possessions from the property. The tenant likely will not be there to do it themselves, and so you have to have people ready to do that. And the tenant or the sheriff will call you to coordinate what time that will be done at. All right, I think that's the whole flow chart. So as you can see, there's multiple different ways this can go down. There's really a something I made for clients to know where their pitfalls are and where they need to pay attention. All right, let's get back to our slides. All right, so we've gone through this. We've talked about the possession. Let's go to the next page. The cost of eviction. So there's two ways to think about your cost of your eviction as we're going through it. You have the general cost of the eviction itself, but really we're talking about the cost to the owner of the property. So they've already lost rent leading up to the eviction. An eviction can take anywhere from 1 month to 3 months, depending on whether we're serving with personal service, whether the court's backed up, whether we can get on the docket fast, whether we accept money at any part and have to restart the process. All of these things can mess with our timelines. Even after we get the eviction, like we said, we have to wait for the sheriff to come out and do the writ of possession if the tenant refuses to leave. And so that could extend our time period even longer. And so all that is rent that you can't collect during that time period. And so that adds to your cost. It also is a potential area for damages to be caused to the property because no one's talking to you about the property. And so you have to consider that as well. So all that kind of plays into what you should think about as a manager of the property as we move forward. And so if you ever have any kind of questions on where you should plan for that, you should either talk to someone who's been through it before or talk to us and let you know. But here are your general costs that you're going to incur through the process, specifically in Madison. So as you can see, my basic attorney fee for a standard residential eviction fee is on there. We charge separately for the initial filing versus going to court. So our total fees could add up to $750 if we end up going to court for you. Now the unlawful detainer itself, just to file it, costs $335. Then once you're filed, usually you have to pay someone else to serve the tenant. That's usually another $20. And then once you've done that, if they don't answer, we talked about that default judgment. That's an additional $52. And then which the 52 is a deal if you consider that you're avoiding the attorney fee of $250. Just to throw that out there. But then once we get through the court/default judgment period, then you have the writ of possession. Filing that's an additional $20. And that's the end of your fees as far as court fees, service fees, and attorney's fees. And after that, it's up to you to coordinate with the sheriff and get your people out there. Now, again, you have to get people out there. Some people, they have friends who will come out and help them. They have people in the management company who will come out and help you. Other people hire moving companies to come out and just move everything out very quickly. You kind of have to figure out what works best for you and your situation and what your owner is willing to pay for. And so that's just a general overview of your costs there. All right. So we've talked about the eviction process just very generally. We've talked about the lease very generally. We've talked about the cost of eviction, kind of some pitfalls people get into with collecting rent and not collecting rent. And we've talked about the moratoriums on them. Now, I will add here, the moratoriums, when I've gone to court lately, haven't really affected the eviction process because either tenants don't bring the right paperwork or the court ask them to verify things that they're not prepared to verify. And so I will tell you, our local courts, from my personal experience so far, have tended to be landlord friendly, and that they understand this has been going on for a long time and that tenants have been taking advantage of it, and that this is time to turn it around and get back into normal operating procedures. So I will give you that kind of good news from a landlord side. So all of that is what our class was on today. If you have specific questions about the eviction process, about collecting rent, about anything we just talked about, our flow chart, our eviction moratoriums, Supreme Court case, I'll be happy to answer them. Appreciate you guys coming today. Hope you had a great 4th. And you guys have me for another, looks like 35 minutes. So feel free to ask questions. Thank you all.
Did you want me to put up the link to the CDC?
Yes, so we do have links for the CDC recent extension that also within that has a link to the form that tenants have to fill out. So you can see what it looks like. I think it's on page 11 or 12 of that order. And then we also have a link to the Supreme Court order that just got signed. I think it was Kavanaugh who did the actual opinion there on behalf of the court. And so Lindsay can throw that up for you and you can go look at that as well.
Yeah, I'm gonna give
It's a
people.
very short order. I think it's about a paragraph long. I think I put most of it in our slide.
I'm just gonna give people a second to click on that first CDC one
Sure,
before
sure.
I put up the other one. But in the meantime, we've got a question there.
It is my understanding that the moratorium, which is what I think you're talking about, is specifically a residential moratorium. Again, the whole purpose of the CDC doing this was to prevent people from being moved from their homes and having to go join family members or friends in their homes. And then when we have a lot of people who aren't used to living together being communal and maybe having the disease of COVID, then we're looking at the ability to spread something very quickly through a community that has high eviction rates, especially when, like early on in the pandemic, jobs were very hard to come by, businesses were closing, people were staying at home much longer than usual and not getting paid. So all those things kind of culminated in the moratoriums. And so they were not meant for commercial use. Now, the commercial timeline for evictions is as a different class altogether. Again, commercial landlord-tenant relationships, yes, they have evictions. Yes, they follow the same basic concept here, but it's really dependent on your leases. You know, with residential leases, it's typically very boilerplate. It's very pre-made, and so you don't have to think much about it. Whereas with commercial, everything is negotiable. And so you really got to figure out what was negotiated in that, what terms we have to follow, what timelines we have to follow. So that's, to me, the big difference in the commercial side. We, at my firm specifically, we handle residential and try and get possession back for our clients. We typically don't get into the commercial side of things.
I am also going to make sure that those 2 links that I just posted are in the follow-up email.
Perfect.
Okay. They should be in there. So when we end the class, you guys will all get the follow-up email with those links. The slides are not included. So if you would like any of the slides or anything that Geoffrey showed today, then just send me an email and let me know and I can send it to you. In case the links are not in there, it could be because the class has already started and it won't let me update. I think it'll be okay. But in case the links aren't in there, then let me know and I'll send those to you as well.
Okay. So yes, Melissa, we can get you a flow chart. Patricia, for residential evictions, we charge $500 for the initial process, filing everything for you and getting everything organized. And then if we have to go to court, it's an additional $250. And I know I say this in all my classes, but just to reiterate, this is not a continuing education class. This is strictly a roundtable for us to have discussions. So I do this strictly for y'all's benefit. So if you have questions, great, ask, stick around, let's chat, let's talk. That's what this was designed for, to be an open-ended conversation. That's why I don't talk for an hour. But you are not required to stick around for an hour either. So if you guys feel like you've got what you came for, thank you very much for coming. We appreciate you.
Oh, I should
Lindsay, do
say
you have any updates you need to give about what we have coming up or anything before we lose people?
I was just going to say that I will also be turning this class into a blog post. So in case you want to check back later and don't want to watch the whole thing again in a couple days, probably sometime before the end of this week, it'll be up there on our website. All of our previous classes are in a blog post on our website too. So in case you missed any of them, you can always rewatch via the link on our website, or you can check out the blog post. We typically have at least one new thing every month to share up there.
Yep. And while I got your ears and no one's asking questions, I will say to all of you, we have our cybersecurity class coming up next. If you have not done it yet, go ahead and do it before the class. Dual authentication. Put it on all of your accounts you have online. All the email accounts, all the .loop accounts, all the accounts you have should be dual authenticated. What that means is that it's going to ask you on your phone to verify that you are who you are and that you're the right person to log into that. It's very easy to do, very easy to set up, and it gives so much protection to you. Makes it so much harder to hack into your system and sit on your email accounts and do things without you being alerted to it. So you'll get more of that with our next class, but that's where we're at now, and don't forget.
Should we give like a very quick rundown on why that class is so important to them?
Yeah, wire fraud is rampant, guys. And what we're seeing is court cases against agents and against attorneys. When wire fraud does occur, they're holding us responsible for that. And it depends on your involvement and your level of protection. And are you paying attention to what's normal in our industry? And are you following the guidelines of what other people are doing? And that's an ever evolving standard. So you need to stay up to date with where we're at with our normal processes and procedures with cyber issues. And like I said, the biggest thing I see people ignoring is that they are not doing dual authentication. It's very easy to do. So make sure you do that so that you can go ahead and protect yourself and your clients. We do also have, I think, a standard form we allow agents to get now, where if you have clients that are going to be doing wires, you can go ahead and send them a form that basically says you're not involved in that process and you shouldn't be involved in that process. You should never be handing out wire instructions. You should never be a middleman for wires. That is up to the settlement office that's doing the closing to communicate all that. It just allows you to tell them that, hey, there's risks. We've talked about it. Protect yourself. Be smart. Make sure you make your phone calls on your wires, all that good stuff. So if you need that, just let us know. We'll be happy to provide that to you.
It is up on our website, but I am happy to email it directly to you if you just want to let me know after the class.
Man, this might be the fewest questions we've ever had in the class.
I know.
Usually people have questions for another 20 minutes after I finish giving my talks. All right, let's get our flow chart back up there. See if we can get people to look at that, see if they have any questions about that process.
Thanks for coming, Rachel. Okay, so question. In the part where they could pay you like a partial payment, the next period where they would pay rent, I'm assuming they would have to pay the full rent plus what they still owe from the last one?
Yeah.
Okay.
Absolutely. That'd be a running ledger. So you'd have to figure out what they owe in total and say, you failed to pay again, you still owe this much from last time. Now it's all together. You have to pay all of that to catch up.
Okay.
And as a landlord, we usually advise that you never collect partials just because it delays your process. Now that is a decision you have to make with your owner. Maybe the owner is like, let's give them another chance. They gave us, 50%, 80% of what's owed. I'll be nice. But that's just a conversation you got to have with your landlord.
That makes sense. In the evictions that you have dealt with, how often do you see like severe damage to property when people have been evicted?
It's the unlawful detainer page again. Yeah. Hold on 1 second.
Mhm.
Was it this one you wanted, or was it the this one? No, it really depends, Lindsay. We've seen some pretty awful damage coming from tenants. The other one with the checklist. So what we have generally found is that the landlords that go through a more rigorous approval process for their clients, even when they default, they don't get as much damage. It's the ones that don't necessarily go through all the other checks for their clients, whether it's credit checks or job checks, income checks, whatever it is they're going to do to qualify for the property. That's usually when you see people that have been in the system before for evictions and they're very smart about it and they know they can delay the process, and that while they're in eviction, it's basically free rent time. And they'll answer it with just the dumbest answers ever because they know that going to court delays it even longer.
Oh
So
man.
they won't let us file for default. So you do get those very savvy tenants that can use the system against their landlords.
Wow.
If the lease states rent due on the 1st, can we state a late fee of 10% of base rent due after the 5th of the month? And if rent/late fee is not paid in full by 7th of the month, landlord may begin eviction proceedings. There is, and I don't know off the top of my head, there is a limit on how much late fee you can charge. I don't know what that limit is, but I don't see anything wrong with the timelines that you've set forth there. Typically, if it's due on the 1st, then that's typically after the 1st is when you can file. You're not on time anymore. Usually your late fee structure is strictly for the landlord to have incentive to get the tenant to pay, but it's due on the 1st, so that's the due date for your rent. And then typically leases are going to be silent on when landlords can begin the process of the eviction unless you go to the default provisions, which says usually you get 7 days. So that's typically where you're going to see that they have to pay by the 7th, but it's not going to say by the 7th. It's just going to say you have 7 days to cure this default because they are technically in default on the 2nd day of the month. And then they are being given 7 days to cure the default. And so that's how that typically works. 7 days are calendar days. That is correct. This is not business days. Because we are in a possession business of the landlord's property is potentially getting damaged during this time period, the courts do a calendar basis, not a business day basis, so that we can move it quickly through the system. Patricia, I believe HAR has some really good leases. We have some of our own that we're always happy to share, but I'm pretty sure HAR has long and short form leases. So I would ask them first because they have a whole committee for these forms, is my understanding. But if for any reason you don't want to go to HAR, I am happy to give you what we got. Yeah, we do have some that we hand out.
Okay, follow-up question. If they had been in the eviction process before, would that show up on a background check? Or you have to go somewhere specific to find that?
It might show up on a credit check. I think those get filed with the credit checks. I'm not entirely sure on that process because I've never had to look at those before, but it does go on a person's financial history.
Yeah.
It's also in the court records, but usually you're not going to see it like in the probate records. You have to go and search that. So it depends how detailed of a background search you do, I guess.
Hmm. Got another question here.
Don't you have to file with the courts in order to be on their credit report, or is it automatic? Again, I'm not entirely sure on that part. You might be right that the landlord has to file something for it to be put on the credit report. In my experience, the landlords I've dealt with, they're less they're less curious about how to punish the tenant and more curious about how to mitigate their own damages. They're like, let's just get them out as soon as possible. They're wasting my money at this point. Like I said, your damages rack up very quickly when a tenant fails to pay. Just like a lot of people think of it as, oh, well, you just missed a month's rent. Well, not really. We missed a month's rent. We missed the next 2 months rent while we evict. Potential damages, or we have to get the property fixed, which is more time that you're not getting paid. Then they getting a new tenant in, and so all that takes precedent. Now, I'm sure some landlords do, after all that's done, want to go after a tenant to be like, you hurt me, I'm gonna hurt you too. But I don't typically get it brought into that. So I've never had to deal with that before.
Are there major differences in the lease that you would give people versus the lease that HAR has?
No. We have some minor differences, but generally a lot of the attorneys in the area are the ones helping draft HAR's leases anyways, and they readily hand them out. And so typically ours are going to be some amalgamation of the HAR lease and other leases that we've formed in the past, and we've kind of combined them all together to make some kind of hybrid. It's not going to be any necessarily better drafting or any worse drafting. It's just sometimes laid out differently. Sometimes it highlights different provisions in a more obvious way. So it just kind of depends. I think I'm required to say that no attorney is better than any other attorney at work at this point or something like that.
The typical commercial.
That's right.
Feel you get.
All attorneys are equally trained and capable of handling your situations. Patricia, thanks for the great questions.
Mm-hmm. I don't know that this is necessarily a question for you, but so when the sheriff comes and you're arranging for someone to take everything out of the property,
yeah,
where does it go?
The curb. So
you just leave it like on the road?
Absolutely. So they literally take it out and they put it on the curb. I think technically there is a like small window where it is still their property and they can come collect it. But generally at that point, if they don't collect it from the curb, it's anyone can come by and grab it.
Oh.
So
wow.
It's definitely not the way that you want to go through that process, especially as a tenant. A lot of times we'll try and work with tenants to say, look, if you'll just leave the property and let us avoid this process and let us avoid having to pull your stuff out of the property, we'll work with you. We'll make it worth your while and make it worth our while because it's so much faster to give us back possession.
Mm-hmm.
And I've seen landlords offer money to tenants to say, look, if you leave with all your stuff and then prove to me that you're out, I'll happily give you $100 to help with moving fees. because I want you out that badly, and I don't want to pay, I mean, close to $1,500, $1,700 for the eviction.
Wow.
Yeah, there's lots of settlements and evictions that people don't think about, especially when you start suing for the actual damages and money up front. You can reach all sorts of negotiations where you're like, look, I'll pay this much up front now. You'll give me an extra few days, and then we'll put it all in writing with the court so the court can enforce it. So it's not always as cut and dry as I've made it. I try and keep my evictions cut and dry because I like simple. But you do have a lot of situations that get complicated, and maybe you want a settlement to help smooth over the transition. So yeah, there's all sorts of ways this can go down. We've just talked about the basic transaction.
Do you have any specific advice based on the ones that you've seen, other than
I saw one recently where it was actually during the pandemic, and the client didn't want to use the CDC moratorium to avoid eviction. And so what we did is we went to the landlord after they filed the paperwork against us, and we said, look, because at that point I was actually representing the tenant. We said, look, we're willing to pay a flat fee up front of this amount, and then we can commit to paying the rent plus this every month moving forward for the next 6 months, and that will catch us up. And then if you will agree to that and give us this extension, we'll put it in writing with the court. And if at any point we miss a payment, then you can go ahead and get a default judgment immediately, and you don't have to go back to court for this. And so we filed that settlement with the court, and tenant did great. They kept up on their payments. They paid the extra every month, and they're caught up and doing great. So
Nice.
yeah. There's definitely an incentive for landlords to keep their tenants. And generally, if they're an aggressive evictor and they're doing it after like the first default, maybe just the second default over a course of a year or two, generally they'll be more lenient during the eviction process to work with the tenants. Other landlords are very lackadaisical, and they'll let 5 different months go by at different times where it's partial payments here, random full payment here. Now we've missed an entire payment here. And you end up actually totaling it up, and you're like, man, you've missed like over the last 7 months, you've missed 2/3 of those if we're actually adding it all up together. And that's when you've waited too long. That's really hurtful for a landlord who has to pay a mortgage. So typically we don't advise people to wait that long. I also typically like to do the evictions based on failure to pay rent because it's the easiest thing to prove. You can't really argue it. The money's there or it's not there. If we try and evict based on other rules, like let's say they have drugs on the premises, or they're being a nuisance to their neighbors, or they've broken some rule that the landlord's put in place, that's just a house rule. These get much harder to evict based on. I've had landlords come to me and say, we want to evict for, the fact that the cops are there and they're breaking rules. And I'm like, well, we need a police report then. We need something to prove all these things you're saying, because we can prove failure to pay rent very easily, but we can't necessarily prove all these other things you're claiming just because.
Yeah.
So I've had people try and evict people because they were smoking on the property when they shouldn't be, and that's difficult. Typically, the best way to do something like that is to use your right as a landlord to inspect the property. There's usually a notice provision in the lease that says you have to do it with 24 or 48-hour notice or something like that. So it doesn't always work. When you have to give the tenant notice that you're going to come in and inspect the property, that gives them the time period to fix everything. But they still miss stuff, and it's still worth it sometimes to be able to do that. Whether it's walking the property and be like, I smell smoke. Well, then you can do an affidavit and you can say that you smell smoke in the property, or we can get someone else to come in who's not related to the situation, make them do an affidavit. So there are ways to evict people for other reasons. It's just the easiest and most succinct and quickest way is failure to pay rent.
Yeah. Interesting. Man, there's so much to it.
All right, guys, we haven't had a question in quite a while. As much as I like just chatting with Lindsay, we do this all the time. So I'm going to give you all another 2 to 3 minutes to ask your questions and have your final says. And if we don't get anything in the next 2 or 3 minutes, I appreciate all of you coming. This has been another great class. We appreciate the opportunity to present these to you guys. And we always look forward to the next one. Like Lindsay said, if you have specific classes you want us to talk about or topics, let us know. I'm always happy to tailor these classes for specific questions. I'm always happy to, after I give a class, go more in detail on a specific topic. If we have lots of questions on a topic and you're like, I want to deep dive this, just let me know. I'm always happy to do some research for you guys and prep for these. I enjoy them. It makes me a better attorney, makes me a better teacher for you guys, so that when you have the questions, I can answer them. And it gives Lindsay a reason to yell at me when I don't have the blogs ready. So we all win.
And if any of you have not already registered for the next class on August 3rd, which is our cybersecurity specifically for realtors class, the link should still be at the bottom of this page right now. That class will be on Zoom and will not be recorded. So you will not be able to watch that after. The only way you can see that is to attend.
All right. With that said, we appreciate everyone coming out today, and we will see you next time. Have a good one.